All right, good afternoon.
Good afternoon, Your Honor.
This is cause number 20-2-723-21, Armed Citizens Legal Defense Network. Petitioner versus State of Washington Office of Insurance Commissioner. Spencer Freeman for the petitioner, Marta De Leon, Assistant Attorney General for the State of Washington. This comes on today for a review of an administrative order. There are a number of issues here. A lot of briefing, I've read through that. I think one thing, I'll just start with the standard of review. I'll just tell you this, the standard of review is covered by the Administrative Procedure Act. And when reviewing the decision of the Commissioner in this case, the Act and the case law requires they use the error of law standard, which means that I can substitute my view of the law for that of the Commissioner. But in doing that, I still must accord substantial weight to the agency's interpretation of the statutes within its expertise. And so in this case, we're dealing with insurance statutes, dealing with the insurance commissioner, and those statutes are within the expertise of the insurance commissioner. So I will give that substantial weight. That does not decide the issue, of course, but that's the basis, the framework from which I have viewed this case, and I'll hear argument on with that understanding that that's a standard of review that we're using in this case. And Mr. Freeman, I'll let you go first on this, and depending on how this goes, we may go back and forth on each issue and do it one at a time. That may make it easier. We'll see how this goes.
Okay.
All right. I'll let you start.
Okay, let's get into it, see how it goes.
Yep.
All right, good afternoon, Your Honor. For the record, Spencer Freeman on behalf of the network. Your Honor, we are here asking the court to overturn the decision of the Commissioner, as well as the presiding officer, their determination that the sale of the network memberships constituted insurance. I will now skip the standard of review since we have just gone through that. For the most part, the facts here are undisputed. I say for the most part because there is one fact that is somewhat in dispute. But the facts are this. So Mr. Hayes, who is actually present with us today, started the network back in 2008, and his intention was to create a network to help those and stop the unmeritorious prosecution of people properly engaged in the lawful use of force. And he decided to do that, and his intent and strategy in doing that was really threefold. One was having a network of people and experts and people available. Two was educate people, and then three was establish the fund to be able to provide some monies to people in assistance if they need it. The education portion of these membership cannot be overlooked, and it feels like the OIC really tries to overlook those, but they should not be downplayed. The network expressly believes that education is the best way to avoid a situation of self-defense, and it's expressly says that on their website, and they go through to great lengths for education and great efforts for education, not only in providing a new member a bunch of stuff at the beginning, but then providing ongoing education to the members. And the network aspect of this shouldn't be overlooked either, providing folks, specifically members, with access to attorneys that specialize in self-defense and experts that have been court appointed and court acknowledged as experts in self-defense, for people to present questions and start conversations, as well as if a situation did come up, reach out to those. Yes.
You need to slow down a little bit.
Okay.
You're talking really fast.
I do that sometimes.
Well,
I will stop.
If we're going for an hour or more, my court reporter is going to start throwing things at both of us.
Okay.
You don't slow down.
She can throw them at me first.
All right.
Okay. So the network aspect of this should not be overlooked either, providing people access to those that have knowledge based on this, not only for ongoing education, but if a situation does arise, those attorneys and those experts are there, and that's separate from the fund. But it is the fund component that the Commissioner does take issue with. I think it's important to note that the fund is funded by 5 sources. It's not just funded by a portion of membership dues, it's also funded by corporate donations. It's funded by bequests, it's also funded with individual donations, and then from time to time, the network management themselves put more money into the fund. So the fund is pooled from a bunch of 5 different places. But it's key to acknowledge that at several points to a member, it's made clear that they do not have a promise or an obligation to this fund. They do not have a right, a contractual right to this fund. If you look at the explanation of member benefits, and I'll cite to the record at AR 580, it says, the network's advisory board will review the facts of the case and advise the network leadership on specific issues of legal self-defense on which decisions to grant financial support rest. And that language is super important, to grant. That is not a right. That is a sole discretionary decision made by the network. And explanation of benefits tells a member that right off. There's also an explanation on the website from the Defense Fund page. I'll cite AR 434. This benefit is subject to a review of the facts of the case as known at the time and a determination it was a legitimate act of self-defense.
Well, and that is the condition. If it is a legitimate self-defense case, use of force, then they're entitled to some help.
I don't agree with that. In the fact that you said it, then they're entitled to some help. The network will not provide them help unless that happens. But if, let's say, a member were to be denied access to the fund, the question really is, can that member then come before you and force them to pay it? Right? That if there was a contractual obligation, then they would be able to do that. Our position is they would not be able to do that. There are other places here throughout
well, if they're not able to do that,
right,
then the Armed Citizens has no obligation to use any of this money for anyone.
Correct.
So this is just what this could be. If you take that to its logical end, then this is just a great money-making deal where this organization can just take money from everybody and it doesn't ever have to pay anything out and they can just build up millions.
Theoretically, that's correct. That's not their intent. Their intent is to help those situations, and their intent is to provide access when they deem it's appropriate. But
and the documents and all of the literature, the explanation of benefits, it says that if it won't be used unless and until the board, this committee, finds that it's a legitimate use of self-defense. That's the condition.
that is a condition in order to be granted access to the fund. That's correct.
What
They
are
will not
the
do
other conditions?
the discretion of the board. They may feel like the situation's not worth it. They may feel like whatever the person's history may not make it worth it. I don't think that it obligates them in that scenario. Just because there's a belief that there's a legitimate act of self-defense, there may be other factors upon which the network's advisory board says this isn't a situation that we should financially support.
Where does it say that?
It doesn't necessarily say that specifically anywhere, but then that brings up a question here is that the definition of insurance underneath the statute says a contract to indemnify or pay a specified amount upon terminal contingencies. I think there's three things here to talk about. One is what's the contract, and then indemnity, and then the specified amount. Well, actually four things, then terminal contingency. But what is the contract? Neither the OIC nor the presiding officer set out to define what that contract is. And we've got to look at what is that contract. Is that contract just the explanation of benefits? Is it the other aspects of the web pages? Or is it the EOB aspect of the web pages, and then also the brochures and advertising materials, which is really what the OIC wants you to look at, because that's where some of those more stronger statements are made, right? Or in the brochures that they got their hands on. It's not on the web pages. It's not in the explanation of benefits. The question is what's the written contract? And then from there, the question is the contract clear? And it's not. If it's not, you get to look at the parole evidence. You get to look at other things like the brochures. But then you also get to look at the declarations of the members themselves, right? So the intent of the network and the intent of the other contracting party has to be important here if we're going to look at what are the terms of this contract when there's no clear one definitive contract like there would be in an insurance policy like for your homeowners or for your car, right? You've got this contract. So here, when you're going to look at the contract and you're going to look at what the benefits were agreed to, you've got to look at all of it. And when you look at all of it, those members understood that they weren't purchasing an obligation for access to the fund. That's not why they were there. So when you look at that aspect of it, they didn't contract for that. So the next question is, when you look at that aspect of it, what the presiding officer did was just say straight away, we don't consider those declarations. And I think that that's an error in of itself when you're going to look at other evidence like the brochures and things like that.
Well, I think if you were talking about a specific claim, if we were in a case where we had a member was making a claim against armed citizens, then the understanding of what that contract was between the two of them, that would probably be pretty relevant. But just for people in general to say, to give a solicited statement that, oh yeah, I didn't think it was insurance, or I'm not sure. I'm not sure how much weight that has in a case like this.
Well, I think I would encourage you to give it quite a bit of weight when if you're gonna look at the brochures also, right? If we're gonna look at parole evidence, we're gonna look at things that are clearly outside the confines of the EOB and the website itself. Then the intent of the parties, I think, is important. But you raise another good point here, and that is that the website itself this is not insurance. And there's no question that by itself doesn't make it not insurance, but it reinforces from the message from the network to the consumer that you're not buying an obligation here, right? You would have the ability to apply for it, and we use the term grant, we'd use the term assistance, and they'd use those terms purposefully. So I would strongly posit that this is not a contract obligation when it comes to access to the fund. So the next question is, under the statute, is what is, and I want to focus on pay a specified amount upon a determinable contingency. We can talk about indemnity in a minute.
Okay, well, let me stop you there.
Sure.
Let's talk about the contract. Let me
get
the state's response to that part of it. Kind of break this up in pieces. I think it'll be easier for us all.
Absolutely, Your Honor.
At least for me.
Marta DeLeon, Assistant Attorney General for the Office of the Insurance Commissioner. The Insurance Commissioner's position has been clear, I think, throughout this proceeding from the administrative level forward, that the contract, as all contracts do, includes the offer, the acceptance, and the consideration that are paid for that contract. And the offer is highlighted or is demonstrated in the marketing materials that Armed Citizen used, which clearly indicate that in exchange for the membership dues that are listed, individuals receive the right to the payment of legal fees in addition to other benefits. And there's no question that these other benefits are a part of Armed Citizens program. And in fact, there's no question that they're lawful and allowed. The Insurance Commissioner has not taken any position or made any statement that they are not allowed to continue with the educational component or continue creating a list of attorneys and experts that members may want to contact. What is at issue here is the promise to pay for legal services in exchange for the membership dues that individuals pay to Armed Citizens. And although there may be many components to that pool, it is still a promise in exchange for consideration. Although Armed Citizens makes a great deal of the discretion that they have, they are not advertising or indicating to their members that they're using any extraordinary discretion or that discretion is so absolute that this is an illusory grant or an illusory condition of their membership. In fact, their membership or their advertising indicates that the benefits of membership are that they receive this assistance, that the benefits of membership are immediate payment of $25,000 in legal services deposited to their attorney or to themselves to find an attorney, and in addition, immediate assistance for bail. The review of these claims that are submitted to Armed Citizens itself says this is not to deny claims, but to ensure that they are proper self-defense claims. So the way Armed Citizens talks about its obligation and its guarantee and its promise to its members is not, this is a slush fund for armed citizens. It is, this is a benefit for members that dues paying members who are in current standing with armed citizens are entitled to as a result of having a legitimate claim for self-defense. And the only review that Armed Citizens advertises to its members and indicates in its advertising materials and even in its membership materials is that that review will be to ensure those funds go to legitimate claims, the way any standard insurance company will do for claims that are submitted by their members or by their policyholders. So this claim that there is no contract because the OIC has been unclear is frankly inaccurate. The OIC has stated in its briefing and repeatedly that it is both the advertising materials and the contract membership agreement themselves that the OIC is looking at, and that is because in insurance, the courts must look at what would a reasonable person understand is the agreement. And the reasonable person would look at both what advertising induced them into accepting an offer and what was offered through that advertising and what's contained in the membership agreement or the documentation that they receive confirming their payment and confirming their membership.
All right, you've used the word the membership agreement. All right, and I saw explanation of benefits and I saw the various pamphlets and everything. Is there, did I miss the membership agreement that has those things listed in it?
No, Your Honor, it is the explanation of benefits that members receive when they, so what I'm talking about is the explanation of benefits that they receive. So there's not another document. It is the advertising materials, the membership kind of packet that is sent out. And those are the two written statements that Armed Citizens itself drafted that the OIC looked at in considering whether or not there is a contract and what the terms of those contracts are.
But the way this works is that these pamphlets are out there, the advertising is out there, the website is out there. People talk and they hear about this. They say, hey, you should check out this Armed Citizen thing. So somebody gets online, they take a look at it, and they see what the rates are for 1 year or 2 years or 10 years and one person or two people, whatever it is. And somebody says, I think this is a great idea. They send Armed Citizens a check, right? That's what happens.
Correct.
And then in response to that, they get back this, okay, thanks for your money. Here's the explanation of benefits.
Yes,
Right.
that's my understanding, Your Honor, yes.
Okay. All right, and so that all happens, and then we get to the situation where somebody gets in trouble and makes a claim, then, and then let's say they don't, the Armed Citizens doesn't pay for it, right? And they say, no, we're not gonna do it. How do we get to a right where they, with this information, the way this explanation of benefits is worded, where do we get to a document or something that's enforceable by the individual against Armed Citizens? What do I look at to conclude that they have this right?
You would look at the explanation of benefits that explains what members are entitled to when they receive, when they pay their dues. And I believe that's found at page 579 in the record, beginning page 579 in the record. That explanation.
This is Exhibit C on your response.
It is.
To your response. Yeah.
Yes.
Okay.
And that explanation of benefits states that on page 579, when a network member is involved in self-defense after calling 911, it explains and begins there with financial assistance and what the member needs to do in order to obtain financial assistance. So it clearly indicates that a member is entitled to these membership benefits, and this is an explanation of how to access these membership benefits. To the extent it is not in here about how or why that financial assistance would be denied, this would be what a member could use in court to enforce their right to that financial assistance, which is listed as a membership benefit by armed citizens. In addition, to the extent there isn't any ambiguity, an individual likely could also use the advertising materials that demonstrate armed citizen advertised this membership as a membership that includes this very financial assistance they were seeking to obtain. It may be a question of fact for the court to determine whether or not the denial of that claim was legitimate, just like it would be in any other insurance matter. And so there may be questions of fact as to whether or not that claim is legitimate, but using these documents, an individual would have, I believe, a basis for enforcing the promise that and the offer that Armed Citizen made to provide financial assistance when the determinable contingency of the need for using self-defense arises. And so
even though there's nothing dated, there's nothing signed, there's nothing like that, there's just, they sent a check in.
Correct, Your Honor, because the basic requirements of a contract are offer, acceptance, and consideration. The offer was made through the advertising, the consideration was paid with the payment of membership dues, and so there is the promise there, the offer, acceptance through sending the consideration, and Armed Citizens' acceptance of that consideration. So there's acceptance from both parties that now these offered rights, these offered promises are due to the member when the appropriate claims arise. So there is the core elements of a contract present here. In a typical insurance matter, these forms would be reviewed, vetted, clear, and absolutely in writing in one single document that is controlling. But because Armed Citizens has not subjected itself to that review process, there is unnecessary ambiguity in their product. Should Armed Citizens choose to become an authorized insurer, it would have the benefit of that review process and a clear contract. But because they are operating outside of the regulatory requirements of insurance, there is some ambiguity in the documentation. But the insurance commissioner has insisted it is both the offer and advertising, the membership confirmation, the explanation of benefits that confirms that consideration has been paid and the offer has been accepted that constitute the contract.
Okay, all right, thank you.
All right. I could just briefly respond. As anticipated, there's a lot of focus that's put on the brochures and the advertising. And it would be an interesting aspect of consumer protection law if the advertising was all of a sudden deemed part of the contracts that were later entered into. It happens, I do a lot of insurance work. I sue insurance companies for bad faith cases. The amount of times I see a commercial on TV even for an insurance company promising you're in good hands with Allstate, and then Allstate treats them a certain way, right? You don't get to consider the good hands as one of the contractual provisions of the policy. Just like you see any other commercial on TV, that those bring somebody in for sure, but they don't necessarily become part of the terms of the contract, especially when those contracts end up in writing. So I think
the difference is, in that case, you have somebody who is clearly subjecting themselves to the insurance commissioner and the rules of insurance, and so they do have to have everything in here. This case is different. Armed Citizens has not subjected itself to the insurance commission, and therefore, I don't have to do all that. And since I didn't have to do all that, I'm not bound by anything.
Sure, that you can say that, it's an easy thing to say, but my example would go beyond just the insurance industry. Like, how many car commercials do you see? Oh, come down, get 0% APR. Oh, well, that only applies if you have an 800 credit score. Well, I didn't know that. So don't I get to 0% APR? Right? The advertising is one thing, and there's consumer protection laws that address those things. It does not mean that it becomes part of a contractual provision. You've got to look at everything. But when we're do you want me to move on to the next? Okay. So when we're interpreting a contract, I think it's important, when you look at the language of 4801040, it's not a lot of words, but it's also not necessarily that clear or that simple. I think to me, indemnity is really clear, but to pay a specified amount upon a determinable contingency, that can apply to almost every contract that exists. You perform a service for me, I'm going to pay you money. The determinable contingency being you performing the service, and I've agreed to pay a specified amount upon that contingency occurring. If we expand it too broadly, just based off of the language, it can apply to almost every contract. The personal injury, I mean, in my briefing, I cited the personal injury attorney contingency contract. The language needs to be viewed underneath an understanding of insurance. So in our briefing, when we included the issues with regard to risk shifting, risk distribution, that's why, because otherwise it's really unclear. The courts have interpreted insurance a very specific way. The learned treatises confirm that across the country. Risk shifting and risk distribution become really important aspects of determining whether or not a contract is one of insurance. Because otherwise, if we're just going to use the terms determinable contingency, almost everything could be if we expand it enough. But the principle of fortuity really becomes important here also. I'm not so sure it's so important for the indemnity portion. We can talk about that in a bit. But for determinable contingency that's so vague, if you're going to look at a contract, there's got to be an aspect of fortuity. And here, those are lacking because of the intentional act portion. But actually, let me look at the specified amount first.
Okay.
The term specified amount, the statute doesn't define it. We're left with the common meaning of those words. And those, to me, are rather simple in of themselves. Specified, specific amount is just that, an amount. This is where that fact is of the undisputed fact versus disputed fact comes into play. The OIC and the Eisentraut really focused on this up to 25% language. And that had been on the website.
Yeah, I understand that was taken out before the hearing.
Not only before the hearing, before the enforcement action at all, right? So it should not be part of the analysis on a cease and desist moving forward. If they had punished them for something in the past, then that may be part of the analysis. But moving forward, it shouldn't be part of the analysis.
So the up to 25,000 was taken out. What was left?
No, there's no language about it at all. There's no language specific that there's a specific amount available. And that was just on an initial contact and or up to, with regard to the bail amount. So there's no language at all about
attorney fees or bail.
Essentially, yes.
Okay.
So I want to get back to my train of thought. So hold on just a second. So when you go back to so what the OIC is relying on with that language gone is the fact that what's left is it references legal costs or bail costs, something like that. They're saying that because it references, in their view, a specific expense or a category of an expense, that's enough underneath the word specified amount. I don't think that it is. I mean, the term specified means specific. And legal costs, man, that could mean almost anything, right? I mean, it could be an initial consultation. It could be a visit with the police. It could be an arraignment. It could be all of it. It's not specified.
Well, okay, good.
Yeah. And without that, talking about general categories, you're actually now violating the language specified amount to begin with. Because that's what those really are, is general categories. And there's no amount. And I think it's important underneath this contract, I think ACLDN, the network, could donate $200 or could grant $20,000 or could pay for 10% of legal costs or could pay for 100%. There's nothing specific in any of the documents that have been presented, either by OIC or by us, that talks about the amount available. Could be $100. I mean, what if all of a sudden this defense was $500,000? I think ACLDN could choose to do it or not to do it. There's no specified amount. There's no limit. There's no minor amount. I mean, there's nothing in here that talks about specified amount. And to allow Eisentraut's analysis to stick actually violates the terms specified and amount. Do you want me to move on to determinable contingency or take a break here? And
Now let's hear from the state on the specified amount.
So, Your Honor, the fact that the specified amount may have come off of the website doesn't change that it was also included in brochures that were distributed. And there's not anything in the record that those brochures aren't even still in circulation. However, excuse me. However, there is also in the membership paperwork, in the explanation of benefits, a statement that an initial deposit is going to be immediately provided to an attorney. So the legal fees and the bail fees remain specified as the types of expenses that Armed Citizens is willing to pay. It's not willing to pay parking fees and other things. It is limited to legal fees and bail fees. That's the financial assistance that they provide, and that is specified. They've not presented any case law that this is insufficient to be a specified amount. The case law provided by the insurance commissioner is that up to an amount is sufficient for a specified amount. And the fact that some of their advertising materials changed over time doesn't change the fact that they had this written amount in place at the time the order was issued on some of their print materials. And there's nothing in the record that that has been fully withdrawn or those materials have been fully altered.
Well, assuming that that was taken out of all of their materials, then what would the state's position be?
It would still be that the legal fees and bail fees are sufficiently specific to satisfy the specified amount requirement in the statute defining insurance, but also that this could be an indemnification product because they are paying the cost of legal fees on behalf of their members or reimbursing reimbursing members for those legal fees if they've already taken them out of pocket. And so this could also be an indemnification for the cost to consumers or to their members for the legal fees that they may incur and bail fees they may incur, which satisfies the definition of indemnification. So there are two bases here for finding that this satisfies either the cost requirement of insurance, either that is a specified amount in that it specifies legal fees, it specifies bail fees, and while they may, there's no limit to those listed in the insurance or in the agreement between between Armed Citizens, and their members. But in addition, the indemnification component of insurance could also be used to satisfy that this is in fact for a particular amount in some form or fashion, or that it is not simply a windfall, unlimited windfall to consumers. There are limits to it, which is what that specified amount and indemnification clause are designed to provide and to ensure doesn't happen as a result of insurance, that consumers don't receive an unmerited windfall.
Okay. Talking about indemnification then.
Yeah, I think it's an interesting lead-in because I think that there is a significant difference between specified amount and indemnification, right? Specified amount, I think, really means that. Underneath an indemnification policy, I think there doesn't need to be a specified amount. I think categories exist, and those policies exist all the time. Your homeowner's insurance, that's an indemnification policy. Car owners, that's an indemnification policy. But indemnification policy is meant to reimburse for a loss. But I do want to comment on the reimbursement. There is nothing in the record that says that the network will reimburse a member for legal expenses or bail expenses they've already incurred. That is completely not true. It is not there, does not happen. There is no reimbursement aspect at all. What's clear in the record is that the network will pay the attorneys or pay the bail company in those situations. They do not reimburse. And I think that's important, but I don't think reimbursement is necessarily the only definition of indemnification. I think covering a loss. So we've got to look at really what does that mean in this scenario. When you look at a loss, it really is something that damage you've incurred as the result of some condition or some act, right? Now here, there is no damage that's suffered by the actor. Let's say somebody was arrested, they engaged in an act of self-defense or they believe is self-defense. They've not incurred a loss yet, and they've not incurred a loss that the network's ever going to pay for, right? There's different choices that they can make. They can move forward without an attorney. For sure, they can represent themselves. They may very well qualify for the public defender's office. They may be able to choose to sit in custody. There is no loss here. Like, it's a different thing than if somebody runs into my car And now I've got a loss because I've got damage to my car. My car is now worth less than it was, or maybe I can't drive it, and it's got to be fixed. That's the loss. There is no indemnification. To call the network's membership's indemnification is completely wrong. And in fact, Eisentraut didn't do it. And there's a reason why she didn't do it, because these contracts are not indemnification. And that puts us back underneath the umbrella of specified amount. And I get that the insurance commissioner really kind of wants to look at these as indemnification contracts, because that specified amount is a problem here, because there is no specified amount. But these aren't indemnification contracts. And I think that the commissioner often confuses the indemnification contract with these other contracts. The best example I can give you that I can think of a contract to pay a specified amount upon a determinable contingency is a life insurance contract, right? That's clear, right? Fills everything we can know about those words underneath the statute. This is not that. So I think that to look at this as an indemnity is a serious mistake. It's just not. And I will also say that the insurance commissioner's concerns about extrapolating out, like, oh, if we take away interpret specified amount as we're interpreting it, or determinable contingencies as we're interpreting it, that results in big problems in the insurance industry. It doesn't, because most of those contracts are indemnity contracts. These definitions have nothing to do with it. The indemnity contracts are much different, but they involve that loss, and that loss just doesn't exist here. Would you like me to move on to the next?
Yep.
Okay, so let's talk about determinable contingencies. Again, it's not defined underneath the statute. We've got to go and look at the plain meanings of the language. When you look at contingency, I look up in the dictionary, it's an event that may or may not occur, condition of being dependent upon chance. Now, I will note that the insurance commissioner has not provided a definition of contingency, and that's important, because every definition of contingency has some element of fortuity to it. And that would be in direct conflict. Any element of fortuity is in direct conflict with an intentional act. You cannot have an intentional act that is also a contingent act. And again here, some of the case law that's being set forth by the insurance commissioner confuses indemnity contracts with paying a specified amount upon determinable contingencies. So when you've got a situation that they're talking about where somebody is, in some of the case law, where somebody, like, their medical bills were covered as a result of being assaulted, and yeah, that assault was an intentional act, but that person, the victim's own insurance company, was an indemnity contract that then paid for the medical bills or whatever. The true analysis and analogy would have to be, because we've cited you can't insure an intentional act. It's against public policy, and that the case law says that, and it's never been overturned. The guy that did the attack in my scenario, he can't insure himself for his own intentional act of the attack. There's no insurance for that. That's more analogous to an act of self-defense. So an act of self-defense is no question an intentional act. Now, the OIC concedes it's an intentional act because they have to, but they want to say it's also a contingent act. But just looking at the words and the definition of the words themselves, an intentional act cannot be a contingent act. They cannot be at the same time, because a contingent act requires an element of fortuity. And that person, the actor who's acting in self-defense, is in full control about whether or not they act in self-defense. So that element of fortuity that I think is really important in looking at any insurance context isn't here, because the actor is in full control. So I think any way you look at this, there is no determinable contingency in an act of self-defense that's being covered by the network.
All right.
Your Honor, if I may follow up briefly on the concept of indemnification. There can be a loss even if there is not the typical loss you would see in a car accident. The loss in this case is the expense of legal fees. And while it's true there may not be incurred legal fees in every instance of self-defense, by a member of armed citizens. That's true for every member or every policyholder by State Farm who's involved in some sort of auto accident. They may not have an actual loss that's covered by their policy because there's lots of different types of policies. But if a member chooses to incur legal costs, if a member has legal costs, that cost is what's being indemnified, or that cost is the amount specified that's being covered. And so there is a loss in that they are now having to incur legal fees they did not have to incur before the determinable contingency of using self-defense. To address the determinable contingency component, case law has found that it is not just chance, or even mostly chance, but future occurrence that is what is at issue in a determinable contingency. It's not that it's entirely unknown, but that it has not yet happened. And the fact that an individual may choose to take some action does not in and of itself eliminate the possibility of insurance coverage. In an auto instance, or in a auto insurance scenario, an individual may choose to swerve to a certain side in order to avoid what they perceive as oncoming traffic or an inevitable accident, and happen to have a different accident in turn. That doesn't mean that that accident will not be covered because it was an intentional decision to swerve. Here, just because an individual has chosen to take an action that constitutes self-defense does not mean it cannot be covered by insurance. In fact, both the Supreme Court and the Insurance Commissioner have already determined that an act of self-defense can be something that could be insured. In the Grange case, the Supreme Court, looking at whether an accident was satisfied or the term accident had been satisfied under the policy, noted that while the term accident had not been triggered under this scenario, under the scenario that it was looking at, which was a self-defense claim, it is possible and not against public policy for an insurance company to create a type of insurance for self-defense. And that exact type of insurance is what's been created by the, I believe it's the Leighton Linden Company. I apologize, Your Honor, my screen is a little too small to see it. The Linden Southern Company, that filing, that policy is found at the administrative record at page 475 through 512. That is the entire filing that was submitted by the company, including the contractual terms of the policy. And what that policy provides is that it will pay legal fees in the event a covered policyholder has a, I believe it's weapons event or an instance where they use a weapon. And like armed citizens, that could be a firearm, that could be a knife, that could be any form of weapon. And that instance will be reviewed by Linden Southern to determine if it actually falls within the claims definitions that they lay out in their policy. And if it does, they will pay the legal fees for that individual consumer up to the policy limits. That's what the Linden Southern contract for self-defense includes. So the Insurance Commissioner has already determined that self-defense can be insured and self-defense events, and the legal fees that can be incurred as a result of those self-defense actions can be covered by insurance, notwithstanding the fact that there is an element of choice and an element of intention in a self-defense act, because the need for self-defense is still fortuitous. Nobody knows today that they will need to use self-defense when they walk out the door this morning. And even at the point that someone chooses self-defense, they are choosing in response to some other action and activity, not as a result of their own choice. In the one instance where armed citizens denied somebody's claim, an individual went out into his yard to fire a gun because their neighbor's dog was barking. That is the kind of thing that may be wholly absent of any, that may be an entirely, I'm sorry, Your Honor, I just lost the word. That may be an entirely discretionary decision by the actor that would not warrant self-defense, that lacks any kind of fortuity. But there is still a fortuity element in self-defense instances, because there is no way an individual could know that they would need to use self-defense. And it is self-defense that is the determinable contingency here. And the need to use it that the hearings officer, the presiding officer below, determined was the determinable contingency element of this insurance. Because the Supreme Court has already determined that this could be covered, and because the OIC has already allowed it to be covered, it is inconsistent to say that self-defense and an intentional act of self-defense can never be a determinable contingency, can never be insured, or that it is against public policy to create insurance contracts for this exact kind of situation.
Okay.
Yeah, thank you, Your Honor. So I want to be clear. I have not said that it would be against public policy to create an insurance policy for these situations. I didn't say that. But the insurance commissioner continues to conflate indemnity policies with policies that are pay a specified amount upon determinable contingencies. When you look at the Brousseau case, they were talking about an indemnity policy where you don't have this language. But we're stuck with this language. This is not an indemnity policy. When you look at the ACLDN, when you can look at whatever aspect you want to look at, the brochures, the advertisements, every web page, this is not an indemnity policy. Any way you look at it. Now the question is, the terms, pay a specified amount upon a determinable contingency, we're stuck with those terms. And when you look at a contingent act, if you want to define fortuity to you don't know what circumstances you're ever going to be faced with. Man, everything in our life is going to be a contingent thing. Everything. Because I am going to respond. I could act intentionally, but I'm going to respond to something that I didn't know was there. I couldn't have known was there in that moment. I mean, obviously, I guess you have premeditated murder, that's a little different thing. But, it expands it way too far to say that. The question is in this moment, this actor made a decision, acted intentionally, and can that act be a contingent act? Because what's being paid for after that is legal costs. We're not talking about paying for medical bills or indemnity or any of that. So the question is this act of self-defense a determinable contingency? It's not. It's an intentional act. And I would stand strong on the fact that there's a line between that, an intentional act versus a determinable contingency. Underneath that portion of the statute, you cannot have these policies. They're indemnity. They've got to be indemnity policies, and that's clearly not what this is. So the other aspect I think that we need to look at real quickly is that of risk distribution. And when you look at other policies, that risk distribution, it means that the risk is distributed amongst everybody else that's purchasing that policy. And I may be wrong, and Ms. De Leon can correct me here, but when an insurance company wants to get a new pool of policies, they apply to the insurance commissioner, and they can sell so many policies under this pool. Everything really is distributed amongst that group of policyholders, and the monies that is distributed from those the premiums from those policies. Here it's different, right? We do have some monies that are put into the pool from membership dues, but we also have it from a bunch of other places. And so that risk distribution.
Even if there's money coming from other sources, isn't the risk still being distributed?
Yes, but it's not being distributed equally amongst the other members. It's certainly being distributed amongst the pool, but that pool doesn't come just from member premiums, which in the case of most insurance contexts, that insurance company's pool of money is coming just from those premiums. It's not coming from anywhere else. At least I don't think anybody's donating to State Farm. So, but I think that's when you're looking at this, that risk distribution is not quite the same here. So when you're going to look at this as whether or not this is truly an insurance scenario. I think, though, that moving into what I think is the last topic, unless the court has something else it needs to hear, and that is of self-insurance. If the court's going to find that this is a contract with a promise to access to the fund, and that it's a specified amount, and that it's based off a determinable contingency, I think this is a classic case of self-insurance, where you have people who are coming together with the same thoughts about a subject, with the same, I would call them like-minded. They want to be educated in a certain way. Most of them are going to be supportive of the Second Amendment. I think that that's clear. And then they want to help protect each other. That this is a group of people that has determined that they're going to insure themselves becoming a member of this.
How do we get, I understand the argument that they want to protect themselves, but they're not signing up and paying their money to protect Joe down the street.
Sure they are. Absolutely. That is one of the reasons they want to be a part of this organization, is to be part of that and help somebody else. Absolutely. I would say if you talk to Mr. Hayes or any other member, I would say that is a big part of why they want to be here. Like my conversations with them, this is almost a political statement.
Well, I understand for the people running this, that's what they're doing, the education. There's a lot more to it than them just wanting to protect themselves. I get that. But, you know, with this advertising, if it goes out to some guy who sees it somewhere and says, you know, hey, I could use that. You know, I'd like to read about this. That's good. That's good for me. If I get in trouble,
yeah,
I might have access to some of these funds. That's good for me. You know,
I do think that almost all of those people, I can't say all because everybody's a little different, but almost all those people also think that I want to be part of a solution to what I deemed to be a big problem. And that big problem being unmeritorious prosecutions of, like, this really comes about guns, right? Gun ownership and the use of guns in certain scenarios. And so, yeah, they want to be what they perceive as part of the solution. I wholeheartedly believe that. And they do want to help protect somebody else who is involved in that situation. I think that to me, that's clear by the materials, and that's clear by the membership itself. If that's the court's concern about whether or not this is self-insurance, to me, this is really clearly self-insurance. It's a group of people that want to make sure that there's access to money like this to help somebody fight the system. And that's really kind of the mentality.
okay.
Your Honor, I do want to clarify one element that I don't think, frankly, I fully understood, and that is the construction of the statute. The statute requires a contract to either pay a specified amount or to indemnify in the event of determinable contingencies. That determinable contingencies clause actually applies to both the indemnification and the specified amount, because you cannot simply have an insurance contract to pay people money. You have to have an insurance contract that pays people money up to a certain amount or for a specified amount upon a certain occurrence. So that determinable contingency applies regardless of whether it is an indemnification contract or a specified amount contract. And so the definitions of determinable contingency and the fact that it must be something happening in the future as opposed to something that's already occurred, those cases apply equally in this case. As far as the pool, Mr. Freeman is incorrect. Insurance companies are required to have a certain amount of capital, several $1 million in fact, before they sell a single insurance policy. And that capital is what is ultimately or initially used to pay claims as premiums continue to come in. Premiums are also required, and a certain percentage of premiums is required to be reserved, but there is nothing that says insurance companies may only pay claims from premiums or indicating that premiums are the sole source of the pool of money that insurance companies use to pay claims. So it's incorrect that that typical insurance companies only pay from the premiums. Insurance companies must have capitalization that exceeds their premiums in order to sell a single policy, to begin selling policies in the state of Washington. And while it may not be the case that you or I would donate to State Farm, State Farm's parent company would infuse capital into a subsidiary in order to allow it to begin doing business in Washington. So there is a lot of corporate donation or corporate exchange that happens in the insurance context. So to the extent there are other sources, that does not alter or affect the fact that this remains insurance, this product remains insurance. As for whether or not it's self-insurance, self-insurance insures yourself. If this were armed citizens insuring itself, Armed Citizens could call it self-insurance, but Armed Citizens is trying to insure its members. And even if, when Frank signs up here in Lewis County and Bob signs up in King County, they both want to ensure for themselves and for each other that there is their funds are available for a legal self-defense claim. They are helping to pool and spread risk among each other and amongst the various members of Armed Citizens. That is the definition of insurance. It is pooling those risks and pooling the premiums earned in addition to whatever monies are available and spreading that risk among the members. The fact that Armed Citizens continues to claim that this is to help others means that it is not self-insurance. It is insurance in the very typical sense, and that risk is pooled and distributed just as it is for any other insurance company. The fact that Armed Citizens calls it a membership does not change the fact that they are still promising to pay a specified amount or to indemnify for legal fees and bail costs upon a determinable contingency. And they are taking those premiums and the risk involved with each of their members and spreading the costs of those risks across the pool of money that they've gathered, just like any insurance policy. The danger in accepting their position and their claims is that it becomes extraordinarily easy for insurance companies in every context, not just the context of legal defense funds or legal defense insurance, but in every context, to avoid regulation, to avoid the consumer protections of insurance, to avoid the capitalization and financial requirements of insurance, and to leave consumers high and dry without any regulation and oversight by simply tweaking a few words to say, oh, well, we don't have a policy amount, we're just going to use a category instead. Oh, this isn't an actual premium, you're not paying to become a policy member, you're paying to become a member of our group, and therefore we can avoid insurance by claiming we're a membership, by claiming we don't have a specified amount, by tweaking language and using semantics. This accepting Armed Citizens' position would allow effectively the deregulation of insurance in many contexts, which is why we have to look beyond semantics to the impact. The impact is of the advertising and of the benefits agreement are that they have promised to pay for legal services and bail services or bail fees to their members from whom they've accepted consideration. And those promises satisfy the definition of insurance, which is a contract to pay a specified amount or to indemnify upon a determinable contingency.
All right, thank you.
Yeah, Your Honor, briefly. So that analysis of self-insurance is wrong. And it's wrong, and I'll give you an example. So I know several companies that self-insure for health insurance. They're insuring their employees health insurance, and they have money internally, and they then dole money out for health insurance. They're not regulated the same, right? It's to go through an analysis and say, hey, listen, it still meets all of the elements of insurance. It's still insurance. Yes, self-insurance is that it's still insurance. It's just not regulated. And to say that, no, it's to insure yourself. No, companies, and you look, even the case cited by the insurance commissioner says the company, governmental entity, or individual chooses not to purchase insurance.
I couldn't understand.
Yeah, sorry, I got going fast again. Even the case cited, the Bordeaux case cited by the insurance commissioner, talks about companies, governmental agencies, or individuals. All of those. But it's not just insuring the company, it's insuring the employees. So let's just say, give you an example, like my neighborhood decided that we wanted to do something like this. We're going to pool our money together, and we're going to keep it in this bank account, and it's going to be there in case somebody comes across and they get charged with a crime and it's really self-defense, and that money is there, right? That's self-insurance. That's not regulated by the insurance industry. So to say that just because it's a group of people, that it's not the group as a whole or the overall entity, let's say it's through my HOA, which is an entity, then that makes it not self-insurance. That's not the case. The case here is whether or not they decided to come together and keep the risk within themselves. And I think that if you're going to find these other aspects of insurance, I think that's what's happened here. And that's certainly, I think, the intent of the organization and the intent of its members.
Anything else?
Your Honor, Erisa does govern self-insurance for healthcare by employer. And the insurance commissioner would say that if an organization, if a community got together and attempted to pool their resources in order to pay for each other's claims in self-defense or home robberies or any other event, that would be heavily scrutinized as potentially insurance. It would certainly depend on the facts and specifics of the particular agreement between the members, but it is entirely possible that that scenario would not be self-insurance because no one of those individuals is retaining the responsibility to pay for their own costs themselves. In the case of employers, particularly large employers, have a legal obligation to pay health care for their employees. So it is a cost that employers must incur, and they can satisfy that either by buying a fully insured plan or by setting aside money to self-insure the health care costs of their employees. So it's a very different context. But this is not a benevolent organization that is simply offering assistance to individuals. This is a for-profit company that is taking money from people based on the promise that they will have funds available for legal expenses and bail fees in the event they need them because of a self-defense act. That is insurance. And anything that looks like this is likely to be insurance. It is not self-insurance unless the individual members are retaining the risk for themselves, or Armed Citizens is insuring itself for these potential costs. But Armed Citizens isn't claiming that Armed Citizens needs this type of insurance or this type of coverage or has these expenses. It's claiming that its members do. And just like policyholders, those members are not self-insuring anything. They are seeking a contractual arrangement to have Armed Citizens and the fund they've created as a for-profit company to pay for those expenses in the event they need them. That risk is distributed among the various members of Armed Citizens and does not satisfy self-insurance, but the actual definition of insurance. For this reason, we believe the Commissioner's final order should be affirmed.
All right. Final word?
Just one brief thing, Your Honor, and because I forgot to mention it before, this new view of the statute that the insurance commissioners has presented, which is that determinable contingencies modifies both indemnification and pay specified amount. I don't agree with that at all. I think a plain reading of the language is that an indemnity contract is different than a contract to pay a specified amount upon determinable contingencies. That or is a disjunctive. And there's no indication that the modifier on the other side of that disjunctive modifies indemnity also. So I think that's wrong.
All right. Okay. I'm not going to give you my decision right now.
Okay.
I'm going to, I'll give you my decision in writing. I want to be intentional, very intentional with the language that I use because I think it's really important in this case. I will tell you that this case has been well briefed and well argued by both sides, and you have not made it easy for me. So I appreciate the good lawyering done in this case.
Thank you, Your Honor.
By both sides. So I will work on that. I've got a 4 or 5 day jury trial next week, but I'll work on this as I can, try to get this to you as soon as possible because I know you're all anxious for the answer. So I'll get that to you as soon as I can.
Great. Thank you, Your Honor.
Thank you, Your Honor.
For your time.